Hi, I just wanted to give a quick update in connection with dealing with leases for premises in New Zealand. So now that we've moved through to alert level 4, which means majority of businesses are now locked down and unable to access their premises or trade from their premises, we have been helping a lot of clients in dealing with those discussions with landlords and also helping landlords respond to tenants' requests for rental holidays and reduction of rent. So I just thought it would be good to remind particularly Australian clients about the different forms of lease that we use in New Zealand. So we have a couple of common forms which you've no doubt come across, including the Auckland District Law Society form, the Property Council, and then there's other bespoke leases which landlords may have developed their own templates. So in terms of the most common form of lease, the ADLS form of lease, after 2012 there were some changes made to that template form of lease which were off the back of the Canterbury earthquakes. So that enabled a new clause to be inserted in the lease which deals with these sorts of no access and I guess emergency situations as we're experiencing now. So if you've got a lease which was on the ADLS form, which was signed after 2012, it might be on the form that includes that specific provision, which is the no access and emergency provision. It basically allows for a fair proportion of the rental and outgoings to be abated. So we're seeing tenant clients starting to approach landlords now, and hopefully they've already opened those discussions and they're requesting an abatement. It will depend on whether you're still using the premises, whether you'll be opting to try and request for a full abatement of rent. Some clients will be using the premises still for storage and maybe servers and other equipment there that will be used by the workforce who are working remotely. So you'll just need to take a fair and commercial approach in terms of dealing with your landlord in that regard. There are other forms of lease like the Property Council lease, which is often used in New Zealand. There are provisions in that lease that contemplate whether or not the landlord has been able to access insurance. So if they're able to recover under their own policy, then that loss of rent insurance policy needs to kick in and the landlord needs to consider that. Other than that, there's plenty of bespoke leases. Most of them will not include the no access for emergency clauses that we have in the Auckland District Law Society or ADLS form. So it's really important that you take a close look at the lease. You also check that there's not a force majeure clause which may apply. Often they don't, and they specifically exclude the ability to suspend payments. So we'll share an article about reliance on force majeure clause and other concepts such as frustration of the contract. In the meantime, I'll publish an article which will be posted below, which just deals with effectively what we need to do in terms of opening up those discussions between the landlord and tenant. And the short story is it really does rely on the parties coming together and reaching a commercial and sensible arrangement. And it might be that it's a month-to-month or a week-to-week arrangement, just to enable the parties to gauge, where we're heading with this. This is uncharted territory, as we all keep hearing. So, we've got to consider that some businesses might be able to open. For example, quick service and fast food restaurants may be able to start delivery. And that might just be in certain regions. So they might not be up to, full trade. So there will need to be some fair and reasonable discussion there around what would be a fair abatement for rent and a discussion around outgoings. So I'll publish this article below. You can go through that. Definitely contact me with any questions. Once you have reached agreement with your landlord, it would be a very good idea to record that at least via email communication, but you might find that either your financier or the landlord's bank might require that to be documented in writing. So if you need a hand with any of that, please reach out. But otherwise, good luck with those discussions. It is absolutely a challenging time for everyone, and definitely lean on industry associations such as the Franchise Association of New Zealand and Retail New Zealand if you do need some support. Otherwise, take care, and I will update you further in connection with the force majeure clauses shortly.